Hi, everybody. We have a case today regarding lender fees when there's a mortgage payout statement and whether those fees are enforceable or not. So I'm sure many of you have seen the situation. You ask for a payout statement from a lender, a mortgagee, and what happens is there's all these additional fees tacked on, and you're wondering, well, are these enforceable or not? Your client starts asking, what are these different fees? Uh, Late payment penalty, this and that penalty or fee. So this case is a nice kind of recap of the lender fees and what can be charged or not. And so what happened in this case is that it was a $120,000 second mortgage, 12% interest, 6-month term, and the borrower did not pay it on maturity. So what the lender was seeking here was around $8,695 in extra charges. And the court reviewed those charges one by one and found that some of them are okay, but other ones are not valid and therefore do not need to be paid. So what is the overarching principle here? So Section 8 of the Interest Act prohibits any kind of additional dollar amounts from being charged that would essentially increase the interest rate. So any kind of penalties, those are not allowed. Any kind of random fees that where the lender did not incur an actual incremental effort to do something. There was no underlying cost or administrative effort. So those kind of things are not enforceable. So for example, there's the NSF fee, non-sufficient funds fee, sometimes lenders charge, and sometimes they charge it every single time a payment is missed. Now, the courts in these situations would look at that and say, well, was there an underlying administrative fee? So maybe the first time when the lender went to the bank and the check bounced, and then they had to contact the borrower to say, hey, what's going on? In that case, some kind of fee makes sense because there was some kind of effort that the lender had to put in because the borrower's default. But if the lender knows that the next 10 payments are not going to come through and they spend no extra effort each time a payment is not made, then they can't really charge those 10 NSF fees going forward. So that's kind of an example of where there has to be an underlying cost or effort to the lender. So that's kind of what Section 8 of the Interest Act explains. And when the court looked at the extra fees, extra dollar amounts in this case in the payout statement, it found that some of them were in fact a fine, penalty, or essentially extra interest. So it's those three things that are not allowed: a fine, a penalty, or extra interest. So the effect would be essentially that these kind of things increase the mortgage's regular interest rate. So the lender is supposed to make money just from the interest rate. They're not supposed to profit from other stuff. And the burden is on the lender to prove that the dollar amounts they're charging are valid. So that's also very interesting. They can't just charge things and then it's up to the borrower to prove that they're invalid. It's actually opposite. When the lender puts something, the onus is on them to explain why that's a valid thing. So this can be maybe used by solicitors whenever they see a payout statement where certain dollar amounts they don't agree with or their client doesn't agree with. They can ask the lender, hey, can you explain what this is and why you're owed this? And put that burden on the lender. So that's important to know. And so in this case, what was struck down was a default correspondence fee. So the court said, no, lender, you cannot charge a default correspondence fee. Also in this case, the lender charged a 3 months bonus at the end of the mortgage. And the court said, no, lender, you can't do that. This is a penalty. So we know the borrower didn't pay you on maturity, but you don't just get to charge 3-month interest at the end. And this is very interesting because I think many solicitors do see this 3-month penalty at the end if the lender is not paid out. So very interesting that the court in this case said, no, the lender is not entitled to the 3 months interest when it's a late payout. Also, there was a default proceedings fee of $500, and the court said, no, the lender cannot charge that. What the court did allow was the interest, which makes sense. Lenders are allowed to charge interest. That's how they make money. And also a mortgage statement fee of $565 because the court found there was real administrative work there to produce this statement. Kind of goes back to what I said before. There has to be some real work to justify the fees. They can't just be arbitrary or act as penalties or act as increasing the interest under the mortgage. So, as I mentioned, the key takeaways here are that the default fees must reflect the actual costs, or the court said genuine pre-estimates. So it's as if both parties are guessing, pre-estimating what the cost would be, such as a mortgage preparation fee. So actual costs or genuine pre-estimates. However, as I said, fines, penalties, or any kind of dollar amounts to increase the interest are not allowed. The 3-month bonus interest on default, also invalid. So again, very important case in reminding us of what are valid and invalid dollar amounts on discharge statements. Thank you very much. Thanks for watching. I'll see you next time.